I'd like to spend a few moments with you and discuss a problem that I've seen in the last few months with folks who have passed away and left their property and property problems to their kids. Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and this is the typical scenario. I get a phone call from one or two of the kids, and they said, Mom passed away, and the house was in her name. What are we going to do about it? And so let me take you through the procedure. So there's a number of questions that have to be answered. The first is, did mom have a will? If mom did not have a will, the next question is, did mom have a trust? If mom did not have a trust, then the property is going to have to pass by intestate succession. That means by the law of the state of Indiana, and it's usually based on familial relationship. So if mom passed away leaving two kids, then the kids are entitled to the house or the proceeds from the house equally. But this is the problem. So the problem is because mom owned the house by herself and she was the only person on the deed at the time of her passing, and if the house is worth $100,000 or more, it's going to require the estate to open up a probate. That means that we are formally going to have to ask the court to go ahead and appoint somebody to be the personal representative who can go ahead and either transfer the deed to the parties or sell the house and divvy up the money in accord with Indiana law. If the house is worth under $100,000, and that would be net, for instance, if the house was worth $150,000 and there was a $60,000 loan, thus the house was only a $90,000 net, there are other ways that we can transfer the property by affidavit using Indiana's summary estate provision. But this is what you have to do. This could have all been avoided in one of two ways. Number one, mom could have had a trust, and in the trust, the house would have been titled, and then at the time of her passing, the house would have gone to whoever she wanted to under the terms of the trust. Or mom could have had a transfer on death deed. That means that the deed that would be in the recorder's office would have said, I, mom, own this property and I transfer this property at the time of my death to my son and my daughter equally. At that point in time, the only thing that we would have to do is do an affidavit of death, and it would be recorded in the recorder's office, and the house would be owned by daughter and son. So these are things that you really have to think about. And so what happens is people really don't think about it because at one time, this house was owned by mom and dad. Dad predeceased mom. Mom did not look at the deed. Mom probably did not speak to a lawyer. Mom passes away and the house was owned by her solely at the time of her death. If you have any questions regarding a Northwest Indiana property transfer, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.